All rise. The Court of Appeal in for the 5th District in the state of Florida is now in session. The Honorable James A. Edwards, Judge, presiding. All persons having business before this court draw near. Give attention, you will be heard. May God save the United States of America, the state of Florida, this honorable court. Please be seated.
Good morning, everybody. Nice to see a big turnout like this. I've already been introduced. My name is Jim Edwards. I'm presiding today. To my right is Rand Wallace, who's been on the court since 2013. And to my left is Judge John McIver, who's been on the court since 2023. And we're very pleased to be here. We enjoy coming here. We've been coming here for years, and this is one of the venues when we travel we'd love to come to best. And that's thanks to Judge Falvey back there. Always treats us well. And we feel very welcome here. We're always glad to see the schools here. Where's Lecanto High School? Raise your hand. Okay. We've got there Mr. Donovan and Mr. Resendez, is that right? Okay, great. And Crystal River High. Great. We've got Ms. House. Okay. And Citrus High School. There we go. Look at there. What's the Citrus mascot?
Hurricane.
Hurricane. Might have to rethink that one, huh? And for that, we have Mr. Tremonte. Okay, thank you. And Mr. Estet. Okay, great. And then we have some members from the Citrus County School Board. Is that what it is? Or the academics? Mr. Ball. Great. And then Ms. Hammerly. Great. Well, thank you very much. And now for the academic programs, Mr. Bach, and Communications Department, Ms. Hammerly. Are you from the school board, or did I get that wrong?
School district.
School district. All right. Well, great. Well, with that, we have 2 cases today on our docket. And the way it works is each side gets 20 minutes per side. And whoever is the appellant, if you'll tell us if you want something other than 5 minutes for your rebuttal, we're glad to have the marshal take care of that. When you're in the green light, especially for the appellant, that means you're in your first 15 minutes, assuming you 5 minutes rebuttal. When you get to the yellow, that means you're into your rebuttal time. When you get to red, that means it's time to stop. And if I see you're going into your rebuttal time and not seeming to notice it, I'll try to give you a little heads up, but there's no promise for that. So with that, we'll call our first case, which is 25-0365, Tamburini versus Citizens Property Insurance Corporation. If anybody hasn't already turned their phone to silent, please do so, because it's guaranteed to go off at just the exact wrong time.
Good morning, Your Honors, and may it please the Court. My name is Sanford Kinney on behalf of the appellant Norma Tamburini, and at this time I would like to request 5 minutes for rebuttal.
All right, very well.
This case is about whether an insurer can delay payment for nearly 8 years and avoid the legislature's mandatory consequence, which is statutory interest. The plain language of Section 627-70131, subsection 5A, requires interest from the date the insurer first receives notice of the claim, not from the judgment, not from the arbitration ruling, not from the neutral evaluator, and not from when the insurer decides that the amount is fixed.
Mr. Kinney, just for kind of also because of the form that we're in here today, you are litigating for your client's right to interest, correct? Not the actual payment of the claim. The claim was actually paid. Actually, the facts of this case are the claim was paid, and then there was also a follow-up litigation which involved more money being paid on the claim.
That's correct, Your Honor.
You are litigating whether or not the insurer should now pay interest for delaying the payment of the claim based upon a statute that requires the claim to be paid within a certain period of time, correct?
That is exactly correct. Your
Okay,
Honor.
thank you, sir.
Absolutely. The trial court's ruling only providing for the prejudgment interest on only a portion of the payment that was ultimately made effectively rewrites the statute and collapses a distinct statutory right of interest into the common law rule that the legislature intentionally displaced. This court should reverse and remand with instructions to enter judgment in favor of Ms. Tamburini for the full amount of the statutory interest from the date citizens first received notice of the claim, which was November 1st, 2014, for the following two reasons. One, the plain language unambiguously requires mandatory statutory interest be paid from the date the insurer first receives notice of the claim if the payment is ultimately made more than 90 days later. And second, the trial court erred by applying and incorporating common law prejudgment interest principles into the analysis for the statutory interest provided in subsection 5A.
And Mr. Kinney, what did your client do to perfect or to specifically identify the claim to include the amount of the claim? I believe counsel on the other side is going to make the argument that your client, you're obviously you filed a suit, so you are alleging right to money, but your opposition, I believe, is going to say that your client never entered into a contract to repair the damage or the additional damage that was caused, to include the subsurface damage. And then there was no date where you actually defined the amount of that damage. You would agree, probably that's the way this case is going to be argued. Is that correct?
I believe that's correct, Your Honor, and a few things on that. I guess as an initial starting point, we're talking sort of two different worlds here. In the briefing, it sort of is like we're comparing apples and oranges rather than apples and apples. Statutory interest as provided under the subsection is displacing common law prejudgment interest. The statutory interest does not require a liquidated sum. It does not require a specific date because the statute itself provides that date. You provide notice of the claim. They have 90 days to make a determination as to coverage, to issue payment or deny the claim, and then the plain language specifically provides any payment made 90 days after the insurer receives notice of the claim bears interest at the statutory rate.
You seem like you're leaving out a phrase, are you? Or made more than 15 days after there are no longer factors beyond the control of the insurer? I mean,
Yes, Your
that's part
Honor.
of the statute.
Yes, Your Honor. However,
I know you're saying it's not there, and again, just, if I could maybe stop the clock just for a minute. This was a sinkhole claim made years earlier.
correct.
Things were fixed up, and then a couple of years later,
The
the
supplemental.
homeowner noticed some more damage and was saying, hey, insurance company, we think this is still related to that sinkhole from a couple of years ago.
Mhm.
They had a dispute. They ultimately got some people out there and figured out there needed to be some more repairs.
Mhm.
And the insurance company ultimately was saying they would pay for some of those repairs, but they're kind of split in two, right? One for the building, right? And then there was other subsurface. They offered to pay or did pay for the building damage, correct?
Well, they initially denied the claim, and it wasn't until ultimately.
Right, no, I understand that, but I mean,
Yes,
ultimately,
they do
they fixed
pay,
the top. But
yes.
under the law and under the contract, were they allowed to withhold paying for the subsurface until the homeowner entered into a contract?
No, it's our position that they were. It's our position that they were not, because although they say that defense, our interpretation of the statute is that all that matters is that initial 90-day window. Whatever beliefs that they have as to the purposes for denying the claim, whether they're going to withhold the payment or the interest that would have accrued on the payment because there's no payment obligation if they've not entered into a repair contract, none of that matters when it comes to the statutory interest in this case, because it doesn't matter on the fixed date, and specifically for the contract. They did not raise that within that 90-day period, and even if your honors were inclined to say, well, it's a factor outside of their control, clearly it wasn't, because they issued the full payment without ever asserting the defense. All they did was say, we're not going to pay you the interest. In the cases cited in the answer brief, almost every single one of them is they withhold the principal payment or the portion of the principal payment, and therefore the interest does not accrue on the principal payment that's owed. Here, they paid the full payment and are now just saying, well, we don't owe any prejudgment interest on the payment that because you did not enter it into a repair contract, but she was never told that she had to. So we think it's completely factually distinguishable from McKee or Nunez, where they're able to avoid paying common law prejudgment interest because they had not entered into a repair contract when they were specifically told that. And in this case, that is not what happened. The full payment was issued, and all that we're arguing over is this confusing language as to whether or not there's the right to statutory interest or common law prejudgment interest. And a lot of the briefing really harps on whether or not there's a liquidation date required. And under common law interest, there's the default rule, which is it's the date that the sum becomes liquidated, either from judgment or arbitration, or you can have the finder of fact, whether it's the court or a jury, relate it back to an ultimate date, a fixed date of loss.
Did that happen? Did either of that happen here?
No, and it doesn't have to, because the statute's plain language specifically says any payment made after 90 days bears the interest. And it's our position that the 15 days outside of their control does not apply here because they never asserted that defense. They never said anything was outside of their control prior. All they say now is in their initial briefing and in their response in opposition that there's no liquidated sum and so we don't have to pay the prejudgment interest. In their response in opposition, as shown on page, I believe it's 1792 through 1797 through 1801, they don't even assert that below, and it's really raised for the first time here that it's a factor outside of their control that does not require the payment of the interest.
What's the case law or statutory support for the requirement that they have to give you notice that they are asserting that claim or they're asserting that affirmative defense?
I don't believe it's that they have to provide notice, it's that they have to actually assert the claim and withhold the funds. And the cases cited in the briefing, Nunez, Alvar, any of the cases, all of them, the insurance company withheld the principal payment. And because of that, it's a factor outside of their control, and so interest does not accrue. But in this case, they issued the payment, and then only when the motion for interest was filed did they say, well, it's a factor outside of our control that you haven't entered into a repair contract. But the whole purpose of why they withhold the principal payment until they enter into a repair contract is the Florida legislature's policy of ensuring that the insureds actually use the money to fix the sinkhole problems. But here they did not do anything like they did in Nunez or in McKee or in any of the other cases where they basically tell the insurer, you're entitled to this money, we agree you're entitled to the money, but we're not going to pay it until you enter into the repair contract as required by the policy. That never happened here, and they issued full payment.
In the trial court, you were arguing that Nunez was wrongly decided. Is that correct?
So we believe that underlying logic in Nunez and Cabrera have problems in maybe slightly different contexts because we believe that the window is confined to this 90-day period. But upon closer inspection, when you really read the words in the cases, again, maybe it's confusing about whether or not they're talking about statutory interest under subsection 5A or prejudgment interest as the common law rule. Some cases, even the MedMal example that we had in our initial brief, they say prejudgment interest under this statute versus common law prejudgment interest. I think there's a terminology issue going on with, but to the extent...
But the argument specifically that was made to the circuit court judge in this case was Cabrera and Nunez were wrongfully decided. Would you agree that was the way it was phrased to the circuit court judge?
Not before the circuit court judge. It wasn't our initial brief. In fact, I believe the Citizens tries to argue that any claim that we have, any argument that we have that they were wrongly decided is waived because we did not assert it below, even though the second DCA in those cases are the only ones to have interpreted the statutory provision that we're discussing, and so the trial court would have had no discretion to decide differently. It was bound by Nunez, at least as they believed it was interpreted. It's our belief that Nunez and Cabrera are wrong insofar as it goes beyond that 90-day window. And second, upon further reading, I believe it's confusing at best as to whether or not they're talking specifically about prejudgment interest, common law prejudgment interest, versus the statutory interest provided under the statute. Because all the cases talk about is prejudgment interest, liquidation dates, all of which would be irrelevant under the plain language of subsection 5A, because it provides that automatic date of any payment. It doesn't have any qualifiers, it doesn't have any exceptions, it doesn't provide for any explanations outside of a factor reasonably outside of the insurer's control. They have to issue payment and make a coverage decision within 90 days, and they did not do that here.
So your client never entered into a contract yet, is that right, or am I misunderstanding?
To my knowledge, not by
At
the time.
least for the purposes of the suit, they may have after.
Yes, that's correct, but they still issued the full payment, and so it sort of defies logic how they would assert, or how citizens could assert that they don't have to pay the interest that would have accrued on the money because they have no payment obligation because there's no repair contract, but they issue the payment but don't want to pay the interest on it. It doesn't.
And how soon after the arbitration and the entry of judgment was the payment made on the full amount?
I think there's a little bit of dispute as to when the precise payment was made. There was one, I believe it was a few months, but if it was in October of 2022, it would have been about 7 months, I believe.
Did they pay some interest on that amount?
Yes, they did. They calculated what they believed under prejudgment interest, the amount for the above ground repairs and not for any of the stabilization. So if your honors were to be inclined to reverse and remand, it would be effectively just a credit to that portion. We're only asking to recover the portion that would have accrued on the money that was not paid. And that also gets into citizens argues that effectively we're seeking double recovery of interest, and that is in no way true. Because the statute provides you can select it, and it also the plain language indicates that if there is a right to prejudgment interest, the insured shall select whether to receive prejudgment interest or interest under this subsection. So there are situations where the statute makes clear that you might not be entitled to prejudgment interest, but you would be entitled to the statutory interest. And based on the court, if they find that prejudgment interest was required to be paid, the insured has the option to choose. And on page 1792 of the record, Ms. Tamburini's motion for interest specifically asked for statutory interest as of November 1st, 2014. The insured made the selection, and we're basically at a point where if courts keep interpreting, or if Nunez and Cabrera could be interpreted that prejudgment interest is talking about the statutory interest provided under subsection 5A, subsection 5A doesn't mean anything. It's just common law prejudgment interest. There is no statutory interest. It would completely eviscerate any work that subsection 5A is doing from this 90-day payment, because then it would just be the common law principles of a factor outside of their control and either the date that the judgment is rendered, or if they have asked the finder of fact to relate it back to a fixed date of loss. There would be effectively no penalty, which is what subsection 5A is intending to do, is to impose a firm deadline for insurance companies to investigate, make coverage decisions, and pay claims. Otherwise, interest begins accruing at day 91 until you pay. It doesn't matter if there's a dispute between how much it's going to cost. You can make an initial coverage determination, pay $50,000, and it turns out to be $70,000. You'll pay statutory interest on that $20,000 gap. That's what the plain language of the statute requires, and what the
What
legislature
citizens raised in its written response to your request for interest was, we sent the check out 2 years ago and we didn't hear anything until just lately, right? I mean, that's in their written response.
They do. That's correct, Your Honor.
They don't raise the other. do
We
they?
were not counsel below. I don't have a perfect explanation for that. All that really matters is ultimately, legally, under the plain language of the statute, they're required to pay statutory interest from the date of first notice, as was specifically requested in the motion for interest. And the citizens also, and I see I'm about to run out of time, but citizens also, if adopting their interpretation, would effectively expand the time frame for them to pay claims, because the statute's plain language also specifically provides that the terms cannot be waived, voided, or nullified by the insurance policy. So any reliance on, well, once we get a judgment or make a determination as to the amount of loss, we'll pay you within 60 days. The plain language of the statute says the statute will trump the policy language, and you have to pay within 90 days of first notice, not 60 days of when a judgment is entered. And I will reserve the rest of my time for rebuttal.
All right, thank you. Whenever you're ready.
Good morning. May it please the court. My name is Ryan Jones and I represent Citizens Property Insurance Corporation. I'd like to start with a preservation issue because I believe that's dispositive of this case. And the way that that would work is if we look at the argument that was made below, the one and only argument that appellant made below was that she is entitled to interest under the statute because the payment wasn't made within 90 days. Citizens counter that argument, citing the Nunez case in two arguments that come from Nunez. The first is that no payment was due because there was not a contract for the subsurface repairs, and if no payment's due, no interest is due. The second is that the arbitration award did not fix the amount of damages from a prior date, and therefore you can't calculate interest under the statute. Appellant didn't respond to either of those arguments. None of the arguments that are made on appeal were made in the trial court below. And we'd submit that is a failure to preserve the argument properly for appeal. And in support for that, we cited the court's Brooks v. State decision, where it held the specific legal argument has to be presented to the trial court below. And that simply didn't happen. Last week, we also submitted supplemental authority. It was the 4th DCA's Oaks decision. And I recognize that's a different district court, but I think it's really illustrative of how the preservation works, because the court walked through the arguments made on appeal, the arguments made in the trial court below, and realized that the two were not the same. In fact, they were so different, it held that it was not preserved. And we submit that's the exact same scenario that we have here, and the court can decide the matter on that issue alone. Now, I also submit that if we get to the merits of the case, which we don't need to do, that appellant's argument fails on the merits. And of course, the details of the different types of interest is not the most exciting topic in the world, but of course that's what we'll need to get into based on what we're dealing with here. And we will agree that there are two distinct types of interest, the common law prejudgment interest and the statutory interest. And I think it's important to understand why those interests exist and what they do to understand why appellant's argument fails. The common law prejudgment interest comes from the Argonaut line of cases. And the purpose of that is to ensure just compensation. Essentially, the law doesn't want a different measure of damages in one case from another. And the easiest way to illustrate that is to consider the cost to repair the damaged property on the date of loss and realize that that might be much less than the cost to repair that damage several years later by the time a verdict is rendered through litigation. Common law prejudgment interest makes up that difference. So it accounts for the time value of money and increases the amount of damage essentially. What's important about that, when we look at the line of cases with Alvarez and Amat and Nunez and Cabrera, they all hold that if the verdict doesn't fix a specific date of loss, then we consider the amount awarded to be the current value as of the date of the verdict. The theory, of course, is that the verdict, the award at the time of the verdict accounts for any increase in cost. So essentially, common law prejudgment interest is built into the award if there is no prior fixed date. And that is the common law prejudgment interest. When we come to the statutory interest, it's very, very different. It is a penalty. And the statute says if you don't issue payment on an insurance claim by a specific date, then interest can be awarded. But the most important part of that statute for purposes of this appeal is the statement that you cannot have both statutory interest and common law interest. You have to pick one of the two. And that's where appellant's argument fails. Because in our case, we had an arbitration award that set the amount of damages. And it did not set a prior fixed date. So what that means is that the arbitration award set the amount of damages that cost to repair the property as of that date. Meaning the increase in the cost since the date of loss is already built into the arbitration award.
But that only matters under the common law.
Correct, Your Honor. That essentially is common law prejudgment interest built into the award. And of course, the statute says you don't get both common law prejudgment interest and statutory interest.
How are they asking for both?
Because the arbitration award already accounts for common law prejudgment interest. It is the increased cost of repairs as of the date of the verdict, as opposed to the cost of repairs at the date of loss. And the reason we can see that is if we look at the common law, a common law breach of contract claim means the party who was aggrieved is
So under your
entitled.
theory, would the arbitration award have to be reduced for them to then be able to apply statutory interest?
Yes, Your Honor, we would have to have something that indicates a prior fixed date or a way to reduce it. And I'd submit that all of the cases that we've relied on and trial counsel relied on below, Alvarez, Ahmad, Nunez, Cabrera, they all,
Because the one thing that is absent under your theory is the choice.
correct.
Since the prejudgment interest is already built in, they didn't get to choose whether to have that or to have the statutory interest. It's one or the other, as you say, but it's not one or the other at their discretion.
It is one or the other at their discretion, Judge, but the case, and this is from a footnote in the Alvarez case, the plaintiff has to present their case in a way that allows the choice. Because plaintiff is the one that submits the theory, and if plaintiff wanted the amount to be awarded to be the amount as of the date of loss, it would be incumbent upon them to make that clear. And I'd submit that starts with the expert's testimony. For example, if they wanted the expert to testify that the cost of the repairs on, I think they said November 1st, 2014 was a set amount, that's the testimony that plaintiff needs to present. And that wasn't done in this case. What they're trying to do is assert the choice after the fact, but they didn't set their case up properly to do that, and that is a shortcoming in how they presented the case. Because now they already have prejudgment interest under the common law built into the award, and they want statutory interest on top of that. And the statute says you cannot recover that way. And just to illustrate for the court how that could be done, in property cases, all of the decisions typically refer to estimates, and many of them will refer to those estimates and how they're created. It's essentially a program, a computer program known as Xactimate, and that has a price list that's updated usually on a monthly basis. And that is what would set the date. For example, the expert would testify to my price list being November 1st, 2014, or May 22nd of 2022. And that's how we would know when that amount is fixed. But again, we didn't have that here because plaintiff didn't do it. And they are the ones that need to set their case up properly to be able to exercise the choice. And
Under the statute, it doesn't talk about prejudgment interest based on when the loss was. It only talked about when payments made.
that's exactly right, Your Honor.
So if they look to the statute, they can go, well, the arbitrator set the amount of this, the judgment was entered for X dollars, but that wasn't paid within 90 days or 15 days or whatever else, so therefore we're entitled to it. And you're saying because they didn't have the arbitrator say, this number is as of a particular date other than today, they've already got the prejudgment interest totally built in and cannot go back and rely on the statute.
That's exactly right, Your Honor. If that arbitration award had either been based on testimony that that was the cost of repairs as of, and I'm going to use the date November 1st of 2014 because that's the date plaintiffs are claiming. If that's what the arbitration award was based on, or if that's what it expressly stated, or if there was an agreement among the parties going into the arbitration that that's what the fixed amount of damage would be, then I would agree they would absolutely have the choice either to go under the statute, calculating interest the way they want, or prejudgment interest under the common law. But they didn't set that choice up properly, and that was solely on plaintiffs to do that. That's not something that Citizens needs to do or needs to worry about. That's the party seeking the damages has that obligation. And because they didn't set it up properly, they can't now have both, which is essentially what they're asking for, because prejudgment interest is built into that arbitration award.
So Citizens doesn't rely on the fact at all that they did not enter into a contract for the subterranean repairs?
We do, Your Honor, and that is focused on that so far today is because that argument was made below in the trial court. It was made specifically at the hearing by trial counsel, but it was not responded to by appellant's counsel, by their trial counsel. And it wasn't raised in the initial brief either. In fact, appellant didn't counter that until the reply brief. And I'd submit that that is a failure to preserve the argument. And the reason that's a failure to preserve the argument, Judge, is because I'd submit that if we're going to address the merits of that, we need to research and analyze whether or not a party that has the right to withhold the payment, but chooses to make it anyhow, call it a voluntary payment, call it whatever business decision they wanted to make, whether that cuts off interest or not. And that's not an issue that was analyzed because it wasn't raised. And so that is where the failure of preservation is. And that's a separate and independent reason that the court should affirm. and could affirm, and we submit that it should. And unless the court has any other questions on the positions, I think we've outlined our arguments, and we'd ask the court to affirm because the arguments weren't preserved properly. And even if they were, if the court doesn't decide that issue, then we also submit that appellant's argument fails on the merits.
Thank you.
May it please the court. A few things in rebuttal. Specifically on the preservation issue, I don't think there's any problem with preservation here. In the briefings, the only argument that was claimed to be waived was whether or not the cases were wrongly decided. I do not believe that those, because the trial court was bound and there was no discretion to be able to render a different decision, that issue can be raised on appeal for the first time. And moreover, this court does not have to rely on those cases in order to rule on this case if the court agrees with appellant's interpretation that they are either so distinguishable factually or that they're talking about common law prejudgment interest as opposed to actually conducting the statutory interest analysis under the subsection.
Has your basic position been the same, that they owed it since they didn't pay within 90 days of the claim?
Yes, and the idea that somehow the arbitration award accounts for common law interest at no, as Your Honor mentioned, no choice by Ms. Tamburini, I don't know where that comes from. That's grafting into the arbitration this presumed choice for common law prejudgment interest as opposed to selecting statutory interest once they had the ability to do so. And I'd really like to go back to the point that a fixed date of loss for prejudgment interest under subsection 5A is not required. It does not matter when the fixed date of loss is because the statute provides the date that interest begins to accrue from. You don't need a fixed date of loss, and it does not matter when the judgment is rendered. Once an amount is determined and payment is owed, the interest accrues from when the first date of notice was. The language is absolutely clear and unequivocal that 90 days, if you pay 91 days, interest will accrue on that first day because it sets that liquidation date rather than needing a fixed date of loss. I guess in conclusion, we would ask that this court reverse and remand and ask and instruct the trial court to award prejudgment interest as all issues have been properly preserved or are able to be brought on appeal in the first instance. And I think it would be incumbent for this court to write an opinion to explain the difference between statutory interest as provided under this section for payments made after 90 days of first notice and prejudgment interest, because those are two completely distinct legal rights to interest. And it appears that the case law is a little bit muddied as to when the analyses are occurring and when entitlement to one or the other actually occurs, because based on the trial court's ruling, after Ms. Tamburini's specific request for statutory interest, by incorporating the common law prejudgment interest principles, it is eviscerating any work that subsection is doing, and it's becoming one general prejudgment interest statute that it clearly was intended to displace and create the penalty, and it took citizens 8 years from the date of first notice.
Did your arbitrator have notice that you were going to be seeking interest under the statute instead of judgment interest?
I don't know, Your Honor. Based on what's in the record, it does not indicate whether there was any.
Your position is that selection should be able to be made, post hoc, and your opponent's argument is no. You have to present that up front so that they know not to sort of sandbox you in here.
Yes. So very quickly on that, all that's required in the line of cases, everything else is interest needs to be pled in the complaint, which it was on page 84 of the record. It just says interest. If this court were to adopt citizens' interpretation that you have to pre-select prejudgment interest or statutory interest, that would be grafting a new requirement into the plain language that the statute does not require. All you have to do is plead for interest, and then you may make the selection based on whether or not prejudgment interest is even allowed in that case. And so it has to be post hoc because at the very beginning of the case, presumably a plaintiff will not know if they're entitled to prejudgment interest. So it would it would strain credulity to believe that you could plead for it right up front rather than doing it post hoc as the facts of the case unfold and the determination as to whether or not you're even entitled to prejudgment interest can be ascertained. And so for those reasons, we would ask that this court reverse.
Can I ask you one more question? I'm sorry. I know
Yes.
that you're at the end of the time, and I apologize. I
We'll give you
believe,
some extra time, don't worry.
I believe what you were saying in this case, that your ability to recover the statutory interest is, although you did not file or enter into a contract for the amount of the repair or perfect the precise amount of the claim, because the insurer paid an amount that they determined to be the full amount of the claim, that satisfies the requirement. Is that correct? It's purely because they paid a specific amount of money that should be the claim that we're focusing on.
Well, it's the specific amount of money that the court entered judgment on. So it doesn't matter whether or not we think the claim is technically worth more or not. It was the arbitrator, the neutral evaluator and the arbitrator came to the decision that the claim was worth $56,128.23. And then that amount was entered into judgment, and Citizens raised no defenses as to paying the principal payment until after the full payment was made, never asserting that a requirement to enter into a repair contract was required in order to receive the payment. And now, in effect, wants to have it both ways, where they make the full payment but say, well, we didn't have a payment obligation until a repair contract was entered into, so we owe you no interest on the $40,000 that wasn't paid interest on.
So the amount of money is irrelevant to the repair that needs to be done. It's just
Yes.
purely, you're saying the amount of money could be, they could have awarded you $5.
Correct.
And you're saying that even though your damages, I mean, to repair a house would be far more than $5, because there is $5 awarded, that you say that satisfies your requirement to perfect the claim.
I think that's exactly correct, Your Honor, because under the statute, only two things are required, which is a payment is made more than 90 days later, and the last portion of the statute says interest is payable when the claim or portion of the claim is paid. They did not raise any defenses. They did not require a repair contract. They paid the sum, and the statute requires payment because it was made, coverage was determined, a payment was made, and it was after 90 days of first notice, and the interest was payable upon payment of the principal.
Okay, thank you.
Thank you, Your Honor.
And if our council can hang around for a little bit, as you're going back to your seat, maybe put your papers down and talk to our students here about,
Absolutely. I wish I had a more interesting case for them.
wow, that might be good too, but why you chose to become a lawyer and especially to doing appellate work as well. So